When you hear the word industry, what comes to mind? Probably factories, right? Big business. But what if I told you that for decades, even the courts in India couldn't agree on what it meant? And the answer they finally landed on way back in 1978 completely changed the game for your rights at work. Okay, let's get into it.
So let's make this personal for a second. Imagine you work at a hospital or a university or maybe a nonprofit. Do you think you're covered by the same basic labor laws as someone working on an assembly line? The answer, for a very long time, was complicated. And it all boiled down to the legal definition of one single, incredibly important word: industry. See, how the law defines that one word? Well, that's what decides if millions of people get basic rights and protections at their job.
So, to really get why this one word was such a big deal, we got to rewind a bit and look at the original rulebook.
All right, here it is, the Industrial Disputes Act of 1947. This was a huge piece of legislation, a really big deal. Its goal was noble, keep the peace between bosses and workers and bring some social justice into the workplace. Sounds great, right?
Well, here's where things got messy. Take a look at the official definition of industry in the law. I mean, just read it. It's a lot, isn't it? Business, trade, undertaking, manufacture, calling. It just throws a bunch of words at the wall. And what on earth does undertaking even mean in this context? It was so broad and so vague, it was almost useless.
And you can probably guess what happened next. Because the definition was so fuzzy, you had decades of just total legal chaos. I mean, courts all over the country were making opposite decisions. One court says a hospital is an industry, another says it's not. There was no rhyme or reason, and that left a ton of workers completely in the dark about their rights.
Yes, something had to give, and it all came to a head in this massive legal battle, a showdown, really, over the water supply for the entire city of Bangalore.
The year is 1978, and you're going to want to remember that year, because it changed everything for labor rights in India.
Okay, so the case was Bangalore Water Supply versus A. Rajappa. In one corner, you have the board. Their argument was, hey, we're not a business. We're a public service set up by the government. We don't even make a profit. But in the other corner, you have the employees, and they're saying, whoa, hold on. It doesn't matter if you make a profit. We work in an organized system. We provide a vital service, and we absolutely deserve to be protected by the law.
And that's the million-dollar question, right? Is a government-run, nonprofit utility an industry? Everyone was looking to the Supreme Court. They had to give a final, clear-cut answer to stop the chaos once and for all.
And what they came up with? Wow. It wasn't just a simple yes or no. It was this incredibly smart, elegant new way of thinking about the whole thing.
They called it the triple test, and it is brilliantly simple. The court basically said, forget all that confusing language. From now on, to see if something is an industry, you just ask three simple questions. First, is there a systematic, organized activity going on? Second, does it work because employers and employees are cooperating? And third, is it producing goods or providing services that people actually want or need? That's it. Simple.
But here's the real kicker, the part that changed everything. The court made it absolutely 100% clear you do not need a profit motive. It doesn't matter one bit if the goal is to make money. If you pass that three-part test, you are an industry. Period. This was a total game changer.
So what did this new test mean for everyday people? What was the real-world impact? Well, it was huge, and it was immediate.
All of a sudden, that protective umbrella of labor law just got way, way bigger. Places like hospitals and universities? Yep, they were in. Nonprofits? In. Government corporations? You bet. The test also made it clear who was still out. Core government stuff like the military and police, or someone working for you in your home. The bottom line, this new legal safety net was stretched out overnight to cover millions, literally millions of workers who had been stuck in that legal gray zone for years.
And this wasn't just some dusty old court case. The legacy of the Bangalore water supply case is still very much alive today, shaping how we think about work. So let's just recap why this case from the 70s is still so important. First, it completely redefined industry to be about what you do, not whether you make money. It put social justice right at the center of the law. It threw open the doors of legal protection to people in all these non-traditional jobs, and its DNA is still found in labor laws and court decisions being made right now.
And that leaves us with a really big question for today, doesn't it? That simple triple test was designed for the world of 1978,
But what about our world? The world of the gig economy, of app-based workers, of AI. How does that old definition hold up now? The answer to that question? Well, that's going to define who's protected at work for the next generation.